All right, hello and welcome to the 2021 Cal-ISBOA HR workshop. You are in breakout session Leaves in the Age of COVID and Beyond. I'm Andrea Marcus, the Membership Engagement Manager here at Cal-ISBOA, and I am so pleased to introduce our presenter today. We have Grace Chan, partner at LCW, here to present on a very important topic. And with that, I will hand things over to Grace.
Thank you. Good morning, everyone. Thanks so much for joining us. Again, my name is Grace Chan. I'm a partner at Lieber Cassidy Whitmore. I work exclusively with California independent and private schools and nonprofit clients. And we are here to discuss leaves, which I know is everyone's favorite topic. Leaves are probably one of the most challenging issues to deal with as an employer. There are so many. They're covered by federal and state laws, as well as sometimes local ordinances. They often intersect with each other and overlap with each other. The reasons for taking leave are often related to, medical issues, which opens up its own kind of whole box of risk. There are wage and hour issues related to it, and leave issues are often somewhat emotional for employees, which adds potentially to the likelihood that it could result in a dispute or the employee feeling like they were treated, callously or kind of, just kind of cruelly, if you will, by the employer. So it can create this whole host of issues with this complex web of leaves that are available to an employee in California. Another challenge, that's kind of unique to leaves is that the regulations and guidance about leaves changes all the time. It's not really a question of changing, periodically or changing occasionally. They really are constantly evolving. And so not only do you have to kind of navigate this web of leaves that are available, but you also have to keep up with this constantly evolving legal landscape. So I know that when I'm contacted by clients about leave issues, it's often out of, sheer frustration, it's trying to do the right thing, really difficult to figure everything out. So we could talk about leaves forever and ever, frankly, and I know that nobody wants to do that. So in the hour we have together, we're going to discuss kind of specific, timely issues related to certain leaves that are, highly relevant right now in the year that we're facing and beyond. Before we dive into that, just a couple of housekeeping items. Please be sure to have a copy of the slides with you. Not necessarily a paper one, electronic one saved somewhere. In the chat box, there is a share file link to download a copy of the slides if you don't have them already. The reason why is because towards the end of the session, we're going to go into breakout rooms to briefly discuss a case study, and you'll need the slides for that because you won't be able to see the shared screen then. So please go ahead and download that share file link. We're also going to have a number of polling questions throughout our hour together. And we're going to try to leave some room at the end for any questions that you may want to discuss. So let me, people are chatting about, oops, sorry. Apologize, I clicked the link. I think I just took you to my website. The link is in the share file box if you are able to, my colleague Kayla is resending it. Okay, so let's go ahead and get started. Here is the agenda for our time together. We're going to talk about family and medical leave issues, which I know is probably out of all the different leaves, everyone's favorite. And I say that, of course, very jokingly, right? Because it's, of course, extremely complicated. The reason why we're discussing it today, though, is because, as many of you likely know, there were very significant changes made to the California Family Rights Act that took effect on January 1 of this year. So we're going to talk about the Federal Family and Medical Leave Act, the FMLA, as well as the California Family Rights Act, the CFRA, including specifically some of the changes that were made to the CFRA that took effect on January 1 of this year. And then we're going to talk about pregnancy disability leave. That is a leave that is provided for under California law, and probably the most complicated fact pattern that we get, from our clients with questions is in the context of PDL and how it intersects with FMLA and CFRA, and kind of what that specifically looks like in terms of the timeline of that leave and what is available. And so we're gonna run through that, as well as look at some examples and do some polling questions and things like that about pregnancy specific fact patterns. Then we're going to talk about paid sick leave, which is an issue that is always relevant, but was, I think, particularly relevant this past year and will continue to be particularly relevant for the foreseeable future because of COVID. And specifically, we're going to discuss some issues related to paid sick leave that are specific to COVID-related issues. So we're talking about SB 95, California Supplemental Paid Sick Leave Program, as well as emergency paid sick leave under the Families First Coronavirus Response Act, the FFCRA, which was extended through the American Rescue Plan Act, or ARPA. So let's go ahead and get started. So if we're going to start with a polling question. So which of these statements are false? I'm going to launch the poll and just give about 30 seconds for people to select. Okay, so we're at 30% of you have voted. I'm going to try to hit 60 before I stop the poll. Okay, we've hit 75%. Let me share the results. So 61% of you said number 1, 13% said number 2, 17% said number 3, and 9% said 4, all of the above. So the answer to this one is 1. 1 is a statement that's false. This is not permitted, and we're going to talk about a little bit later why that is the case. Number 2 on this polling slide was an employee may use CFRA leave to care for an adult child with a serious health condition. That is one of the new requirements from the changes to the CFRA that took effect on January 1. So that is permissible. Number 3, an employee who exhausted emergency paid sick leave under the FFCRA in 2020 is entitled to additional supplemental paid sick leave in 2021. That is also correct, and that is what is provided for in SB 95, and we're going to talk about that as well. Okay, so we're starting with the Family Medical Leave Act. And I feel like every time I present on this, even though it's an important topic and it's one that I know everyone has to deal with at some point, if you have, employees that are taking medical leave or family-related leave, but it's one where I think everyone just kind of shudders and doesn't want to dive deep into it, and I understand why. So we're going to break it down a little bit. So as I think many of you know, FMLA is the federal law. It requires that private employers who have 50 or more employees, and is calculated during this 20 plus calendar work week period, provide this leave. In order for the employee to be eligible for the leave, they have to have at least worked 12 months and worked the 1250 hours during the preceding 12 months. The FMLA has not changed recently in terms of those requirements. So the FMLA is still as it was before this year. The CFRA, however, was significantly expanded with the changes taking effect on January 1st of this year. Previously, the CFRA also had an employee, a requirement that there were 50 plus employees within by the employer in order for the CFRA to apply. However, one of the key significant changes was that the CFRA now applies if an employer has 5 or more employees. And that is a big deal because there were a lot of schools that had, less than 50 employees that didn't have to think about the CFRA or the FMLA. There was a brief period of time where California had implemented this new Parent Leave Act, which provided for essentially baby bonding leave under CFRA if you had between 20 to 50 employees, for example. That has now been eliminated with the new CFRA legislation. And so this is a big deal, because again, previously there were schools that really didn't have to think about CFRA, frankly, and now we do. And so that's something to be aware of. The CFRA new legislation, there used to be a geographic requirement. You have to work within a certain mile radius of the employer. That was eliminated as well. For many schools that doesn't apply unless you have multiple campuses that are really far away from each other, but that just kind of FYI that was eliminated also. So under the FMLA and the CFRA, the reasons that leave is permitted, there's one really key difference that has always been in play between the CFRA and the FMLA, which is with respect to pregnancy. So pregnancy and any sort of related medical conditions or disabilities tied to pregnancy has always been a serious health condition under the FMLA that would qualify an employee to take FMLA leave. It has never, ever, however, been considered a serious health condition under the CFRA. And that is deliberate. And we're going to talk about why. And I'll just give you a little kind of preview of it, which is the reason why California excludes pregnancy and pregnancy disability from the CFRA is because they have pregnancy disability leave, which provides for 4 months of leave per pregnancy, basically. And also because California deliberately wanted to reserve CFRA for baby bonding purposes after an employee was disabled due to pregnancy. And so you cannot run CFRA concurrently with pregnancy disability leave for that reason. The California legislature just specifically set up CFRA so that it could not be used for disability, so that employees could have it available for baby bonding leave purposes. So that's one of the key differences. That's not anything new, but I just wanted to highlight that because that is one of the critical differences between the FMLA and the CFRA. So some of the changes to the CFRA is that the CFRA includes additional family members that you could take CFRA leave for if those family members have a serious health condition, including a grandparent, a grandchild, or a sibling. And that is pretty significant as well. And we've already had a number of schools where employees have requested leave due to taking care of a sibling, for example, because of COVID or other reasons. FMLA excludes adult children, but the CFRA does allow for leave to care for an adult child with a serious health condition. Just to note, when I say adult child, I don't necessarily mean adult dependent child. There were exceptions for adult dependent children. That has been, it's not that it's eliminated, but it's been expanded. So it's just adult children, even if they're not a dependent for you, if they have a serious health condition, that you could take CFRA leave to care for your adult non-dependent child with that serious health condition under the new CFRA regulations. And baby bonding is a reason for taking leave under both the FMLA and the CFRA, and we're going to see how that plays out a little bit later. Some additional reasons for leave. Under the FMLA, you are able to take leave for military exigency. So when you have a spouse, child, or parent that's called to active military duty, it also allows for military caregiver leave. So basically, when you have a spouse, child, or parent that's with the next of kin service member with illness or injury, basically if they become injured in the line of duty, you can care for them. Under the CFRA, there's only exigency related leave. This, I will say, this kind of rarely comes up, but we've included the slide with the information in case it does come up at your school. There weren't any changes to this with regard to the new legislation. So some other key differences between the FMLA and the CFRA. So generally speaking, you get 12 weeks of leave under the FMLA and the CFRA. One key difference is under the FMLA, you get up to 26 weeks for military caregiver leave. That's not anything new necessarily. I mean, not necessarily, it's not anything new. That was always the case when military caregiver leave was provided for. Under FMLA and CFRA, there is no minimum amount of leave for a serious health condition. So it's not that you have to be out, for example, for 2 weeks or for 4 weeks in order for it to qualify for FMLA leave or CFRA leave. There's no minimum amount. There is, however, a restriction for baby bonding leave under the CFRA. And by restriction, I mean that employers can require that baby bonding leave, which can be taken intermittently, be taken at a minimum increment of 2 weeks. So you can require that an employee who's taking intermittent baby bonding leave take it for a minimum duration of 2 weeks, except for on 2 occasions when it can be less than that. So it's kind of a 2-2 rule, basically. So it's usually, you can require 2 weeks, except on 2 occasions, it can be less than 2 weeks. So if an employee wants to take 1 day of baby bonding leave for some reason, for example, that's permissible on 2 occasions. You can always choose to allow for more if you want it to be generous, but you don't have an obligation to do so. One key difference between the CFRA and the FMLA as a result of the new CFRA regs that took effect in January 1 is that previously, if you had spouses that worked for the same employer, which is fairly common with a lot of our school clients, under the FMLA, the spouses only received a collective 12 weeks for baby bonding. So both parents I'm sorry, it's actually spouses of FMLA. So both spouses, they would only get a collective 12 weeks. So one spouse would take maybe 8 weeks, the other one 4 weeks, or 6 and 6, for example. You did not have to give 12 weeks for each person. Under the CFRA, however, it provides that parents, so not spouses, but the parents, they can each receive the full 12 weeks. So we're talking potentially 24 weeks that are distributed amongst two parents that work for the same school. And that's something new as well, as a result of the new regulations. Another key difference that I did not include in the slide, but just so that you're aware, is that the CFRA also eliminated the key employee provisions. You may have heard that term, a key employee is basically one of your highly compensated kind of top employee within the organization, that there are certain things that you could provide for key employees regarding their right to reinstatement and things like that. Basically kind of allowed the employer more flexibility for how to handle key employees. That has been eliminated under the CFRA. So there is no more provision. There are no more provisions regarding key employees. And so what that means is that even though the FMLA still has the provisions pertaining to key employees, because the CFRA has eliminated that, it's effectively meaningless now. There's no, no provisions and no language that you should really be using with regard to key employees anymore. So, so under the FMLA and the CFRA, leave is unpaid. There is the opportunity for employees to substitute certain accrued leaves, and there's also the opportunity for the employer potentially to require an employee to use their accrued leaves as well. One of the key differences is that in California, if an employee is receiving state disability insurance benefits, so SDI, what the state has said is that you cannot require the employee to use any of their accrued leaves then. They can choose to do so, but you can't require that they do that. So that's one of the key differences. And that was from the first polling question, the first answer that was wrong, that was why that answer was wrong. Because in California, you cannot require employees that are receiving SDI to be required to use their accrued leave to receive supplemental pay. Under the FMLA and the CFRA, the employer has the obligation to continue medical benefits. That's always been the case. That's not anything new. They also, under both the FMLA and the CFRA, employees that are taking leave have the right to be reinstated to their either the same or the equivalent position. There is an exception to this, which did come into play this past year as everybody was looking at their organizations and restructuring and doing layoffs potentially, where an employee that's on the FMLA or CFRA leave is not insulated from being impacted by any sort of non-discriminatory business decisions, such as a layoff, for example, or a restructuring. It doesn't mean that you cannot lay off an employee who is on FMLA or CFRA leave. However, I do want to be clear that because CFRA and FMLA leave are statutorily protected leaves, if you do choose to terminate or lay off an employee who has been recently on or is currently on FMLA or CFRA leave, that will be scrutinized, pretty heavily if the employee were to challenge that. And so it's really critical. It's always critical to be able to show the legitimate non-discriminatory reason for your decision, but it's particularly critical if you have an employee that is on leave or was currently taking FMLA or CFRA leave. So let's move to another polling question. A fourth grade teacher, Dave, has been out for 12 weeks due to complications from his diabetes. He provides a doctor's note after 12 weeks on leave stating that he will need to be off of work for another 5 weeks. What steps should the school take? Here we go. Okay, we're at 81%, so I'm gonna stop the poll. So 96% of you selected C, 4% selected B, no one selected A, which I'm glad to hear that no one selected A. So the answer here is C. And so this is the headline from this case study or this polling question, which is that under the Americans with Disabilities Act, finite leaves of absence, meaning, so it's not a leave of absence where you have no idea what the expected duration is going to be, there is an end date, is considered a reasonable accommodation. And so just because an employee has exhausted his or her FMLA or CFRA leave doesn't mean that the school can just terminate their employment if they need more leave. It triggers the employer's obligation to engage in an interactive process to determine whether they have a disability, that entitles them to accommodation, and then what reasonable accommodations might be available. There are cases that basically say that unpaid leave as a reasonable accommodation, when it's for an expected duration, a finite period of time, up to, in some cases beyond 1 year, is considered reasonable. But 1 year is generally the initial threshold. So it's almost assumed that basically if the unpaid leave is for less than a year, about a year, it will likely be considered reasonable. Okay, so let's look at another case study polling question. Dave is able to return to work after being out for 17 weeks. The school would like to make him a floating substitute teacher for the remainder of the school year. Is that permissible? Let's watch this. Okay, so 32% said yes, 18% said no, 50% said the very lawyerly answer of maybe. So the answer to this one is no. The CFRA and the FMLA require that employees that are on FMLA or CFRA be reinstated to the same or a comparable position. And so being a floating sub is likely not a comparable position to his prior, just permanent teaching position. However, it could be permissible to teach, for example, at a different grade level. So he was a first grade teacher and you move him to third or K, for example, or something like that. That could be permissible. Okay, next case study. The school can require an employee on CFRA baby bonding leave who is receiving paid family leave benefit payments from the EDD to use his or her accrued vacation. Let me watch this poll. Okay, so 4% said yes, 93% said no, 4% said maybe. So the answer is no. And for the reasons that I just mentioned at the beginning, this is one of those check-ins because everyone's paying attention to the questions. But no, the answer is no, because if an employee is receiving state benefits, then the California regulations say that the employer cannot require the employee to use their accrued leave, but they can choose to do so if they want to, but you just can't require them to do so. Okay, so before we move on to the next topic, which is pregnancy disability leave, I see there's a couple questions in the chat box. So the first one is, on ADA leave, once CFRA and FMLA is exhausted, is the employer obligated to continue benefits, or can the employer put the person on COBRA? So the answer to that is most likely you do not have to continue benefits, and often unpaid leave does not include continuation of benefits. However, the big however to this is that it depends on what your past practice has been, because we can't treat disabled employees differently than how you've treated other employees. So for example, if you consistently, for employees that are unpaid leave, discontinue their benefits, then it's not an issue to do that here. If, however, you typically do continue benefits for unpaid leave, then it could look like it was discriminatory against the person who's disabled that needs unpaid leave. In the majority of situations, though, schools do discontinue benefits to employees that are on unpaid leave as a reasonable accommodation. And that's part of the reason why unpaid leave is reasonable, because there really isn't any sort of added cost to having an employee on unpaid leave. There's another question, why if his job protection has been exhausted? And I think that pertains to the case study about returning the teacher to the floating sub position. The reason why is because the FMLA and the CFRA provide, and just as a reminder, the case study was that, he had returned, I'm sorry, let me just go back. So he's returned after being out for 17 weeks. And the FMLA and the CFRA say that an employee who has been out on statutory leave has that entitlement to reinstatement. There is also language in it that says that basically they need to return or they kind of lose their rights to reinstatement and everything like that, unless they continue to be out at the employer's permission, with the employer's authority, basically. And so the regs account for the fact that there could be continued leave as an accommodation, for example. And so those reinstatement rights still apply, even though that person is on unpaid leave as a reasonable accommodation for those 5 weeks after he's exhausted the 12 weeks. Okay. Let's see, there's some questions about coordination of benefits. So I will say that the general rule is that with regard to coordination of benefits is that if an employee is collecting money from the state, so SDI basically, then you cannot require them to use their accrued leaves to supplement the pay, but they can ask for it. And so if they want to coordinate using their accrued leaves, that's permissible. And a lot of employees do that because they want to receive a full paycheck, for example. But if they don't want to do it, we cannot force them to do it if they're collecting SDI at the time. Okay, so we're moving on to pregnancy disability leave, which, as I mentioned, I think the coordination of PDL with CFRA and FMLA is probably the most common question that we get from clients. Even during this COVID age, I think there was something in the water and a lot of people pregnant and having babies. And so it's come up a lot recently, even with COVID, but it's something that just consistently comes up a lot. So pregnancy disability leave is a California specific leave. It's provided under California law. It's not a federal law. And it provides for 4 months, or technically 17 1/3 weeks of unpaid leave time for pregnancy related disability. So just to confirm, because I get this question a lot, it's not per year, it's per pregnancy, just for context about that. It can be used for disability before and after birth. So it's not uncommon where employees will be disabled for a period of time before they actually give birth. I think the default sometimes is about 4 weeks, but sometimes it's more. And then also for the disability period after they give birth. And so typically for an employee that gives birth, not a non-C-section birth, it's usually about 6 weeks of disability leave. For a C-section, it's usually 8 weeks. But I just want to emphasize that that's not a default standard that you just apply unilaterally. You need to kind of get the doctor's note from the employee to determine what their actual disability period is. But typically that's the amount that the doctor gives, but it's not an amount that you should just assume necessarily for an employee. The employer under PDL, the employer can require substitution of sick leave for unpaid leave unless the employer and the employee is getting SDI or disability payments, as we talked about. The employer cannot require the use of vacation leave. You can require sick leave. You cannot require the use of vacation leave. And PDL, just like FMLA and CFRA, under PDL, the employer has an obligation to continue medical benefits for up to the entire period of PDL. So that means that this is in addition to, for example, FMLA leave, where they might get 12 weeks of health benefit continuation. If the employee is disabled by pregnancy for longer than that, they could continue to get health benefits continuation for up to 28 weeks total, basically. So as I mentioned, the relationship between PDL, FMLA, and CFRA is uber complicated. It's very technical, depending on the employee's due date and how they give birth and how they're doing before and after and when they want to take baby bonding leave. But the gist of it is this. As I mentioned, the CFRA does not include pregnancy or any sort of disability related to pregnancy as a serious health condition that would qualify an employee for CFRA leave. So basically, while the employee is pregnant, CFRA leave is out. CFRA leave is not applicable unless they have something else come up, basically, like something, they're taking care of their mom for a serious health condition or something like that. But CFRA is not applicable while the employee is pregnant. After the employee gives birth, CFRA is also not applicable while the employee remains disabled. And that period of disability, as I mentioned, it varies. It's specific to the individual. It's often 6 weeks for a non-cesarean birth. It's often 8 weeks for a C-section, but it depends on the employee. But CFRA does not apply yet until the employee is no longer disabled. So while the employee is pregnant and disabled by pregnancy, the only 2 leaves that are available are PDL and FMLA. FMLA is 12 weeks, as we know, and PDL is 4 months or 17 1/3 weeks. And so you can run FMLA and PDL concurrently. And so when an employee starts their disability period due to pregnancy, which varies by the employee, you would run PDL and FMLA concurrently. Both require that you continue their health benefits. Both do not allow you to require use of accrued leaves if the employee is collecting SDI or disability payments, but you can run them both concurrently. So for example, you could have a situation, I'll just use myself as an example. I know some of you on the Zoom are aware of my family situation, but so I gave birth to twins 6 years ago now, but I ended up being disabled by the pregnancy at the end of my second trimester. So I had like a whole 3 months left where I was still disabled, like on bed rest basically. And then after I gave birth, I was also disabled for a period of 6 weeks afterwards. So that means my total disability period was approximately 18 weeks. And so my employer ran the PDL concurrently with FMLA for my first 12 weeks, 3 months, which was when I was on bed rest. I then coincidentally did give birth at that time. So the timing of it was actually very precise because I just like to be helpful to my employer. So after 12 weeks, I gave birth, and then I was disabled for another 6 weeks after that. So for the 6-week period after I gave birth, FMLA was no longer available, but PDL was still available because I had not exhausted the 4 months. So I had 6 more weeks of PDL where I was, still disabled, and then I shifted immediately to baby bonding leave. So, and then I had 12 weeks of baby bonding leave, in addition to any specific leaves, provided by your employer. So what that means is that I had 4 months of leave for disability, and then I had 12 weeks or an additional 3 months. So I was out for 7 months. I was out for the whole hog 7 months due to this twin pregnancy. And that's generally what this looks like and what this chart is meant to reflect. So pre-birth disability is covered by FMLA or PDL. Post-birth disability covered by FMLA or PDL. Baby bonding. Okay, so baby bonding is where there is an overlap between FMLA and CFRA. If a pregnant employee who has given birth, has recovered from the disability, does actually have FMLA leave remaining, which is not often the case, frankly, but they do have FMLA leave remaining, let's just say. Baby bonding leave is a qualifying reason for FMLA leave. So once the baby bonding period starts, FMLA and CFRA would then run concurrently if there is any FMLA remaining. If there isn't any, then it would just be CFRA. So then the baby bonding leaves continues for 12 weeks, which they can use intermittently, or they can just take in one whole chunk. So you can see kind of with my own example of my leave that pregnancy leave can be actually very long, depending on what the circumstances are with the employee. And they intersect and the leaves do run concurrently, but not in even intervals because PDL is 4 months, FMLA is 12 weeks, and CFRA doesn't apply until the employee is no longer disabled. So let's look at a case study. A teacher at the school goes out on PDL leave 4 weeks before summer break. 4 weeks after going out on leave, she gives birth to a healthy baby. Summer break is 9 weeks. The teacher's FMLA, CFRA, and PDL leaves run during the summer break. True, false, or maybe? Okay, so 17% said true, 58% said false, 25% said maybe. The answer here is false. In cases where a school is closed for a week or more, so for example, your spring or summer breaks, that time does not count against the employee's FMLA or CFRA leave entitlement. So even though an employee was taking leave up to, for example, your summer break, over the summer period, they're considered just like any other employee, basically. And that time over the summer does not count towards their entitlement. However, with this particular fact pattern, once she returns in the fall, would she be taking PDL then? Likely not, because she's likely no longer disabled by pregnancy. So, I mean, we don't know for sure, of course, but likely under normal circumstances, barring any sort of, something particular that happened, she would not be. So it wouldn't be PDL when she comes back, but she could take baby bonding under FMLA and CFRA when she comes back in the fall. I'm going to skip this polling question since I basically just answered it, and in the interest of time. But the answer is yes here. The teacher is entitled to at least 12 weeks of leave once the summer break ends, as I mentioned, but it wouldn't be PDL, it would be FMLA or CFRA bonding leave. And then I'm also going to skip this one in the interest of time as well, because we've talked about it, but she is entitled to health insurance. Yes, I think we all know that the employee would be entitled to health insurance while she is taking statutorily protected leave, FMLA, CFRA, or PDL leave. So we're moving into paid sick leave. So paid, as everyone knows, I'm sure, California has a paid sick leave law. It's codified in the labor code. It requires that almost all employers provide the greater of 24 hours or 3 days of paid sick leave per year. Sick leave has to accrue at a minimum of 1 hour per every 30 hours work. The accrual can be capped at 48 hours, or you can provide an annual lump sum of at least 24 hours or 3 days. This is applicable to employees who work more than 30 days. Some things to keep in mind is that the paid sick leave law provides for kind of expanded use of sick leave. So there are reasons for paid sick leave. We've included them in the slide, but it's not just for if you are sick. So for example, if you're a victim of domestic violence or stalking, you can use sick leave to go seek, certain protections under the law. Another thing to keep in mind is that there are local sick leave ordinances kind of spread out throughout California. So you want to make sure that you check, and they come up, they kind of sprout up from time to time, so you want to make sure that you kind of periodically check your local area, whether they have an ordinance that applies to this. So next polling question. Bill has worked for your school as a custodian for 18 weeks. Bill works 40 hours per week. He wants to take 3 days, 24 work hours off because he has the flu. He has not taken any time off since he began employment. At a minimum, his 3 days off, 24 work hours will be paid. True, false, or maybe? Okay, so 84% of you said true, 16% said maybe. We had 70% response rate. So the answer here is true. So notice what is not included in this case study. What's not included in the case study is how much leave, sick leave, he was provided by the employer. And that was deliberate because we don't actually need that information to know if the answer is true, false, or maybe. The reason why is because an employee has to earn paid sick leave at a rate of not less than 1 hour for every 30 hours worked, beginning at the start of employment. And so based on 18 weeks, times 40 hours per week, for example, which it says he works, that would be 720 hours. And 720 hours divided by 30 is 24 hours of sick leave. Alternatively, if the employer gives the minimum annual allotment, basically lump sum, that is also 24 hours or 3 days of sick leave. So we know that he at a minimum has 3 days off or 24 hours of sick leave, and that he has not taken any time off since he started his employment. So we know the answer to this is true because what he's requesting is to take essentially the minimum amount that he would be entitled to under the law. And so even though the case study doesn't disclose how much the employer actually gives him, we know that the answer here is true. So turning to COVID-related issues with regard to sick leave, the first big one, of course, is SB 95. SB 95 took effect on March 29th, and it provides a supplemental paid sick leave program that California mandates. And even though it provides for a list of like 7 different reasons when an employee is able to take this kind of supplemental paid sick leave. So for example, if you're subject to a quarantine or isolation period related to COVID, if you've been advised by a doctor to self-quarantine because of COVID, you're experiencing symptoms of COVID, you need to care for a family member who is subject to quarantine because of COVID, you're caring for a child whose school is closed or unavailable due to COVID on the premises. I just want to highlight that. It's because of COVID on the premises, not because the school was closed in the fall, for example, and never reopened. It's because of an exposure that happens on campus. you're going to a medical appointment or vaccine appointment, for example, to get to get the COVID vaccine, or you're experiencing symptoms related to COVID that prevents the employee from being able to work or telework. And so this took effect, as I mentioned, on March 29th, but it was retroactive to January 1. And so some of the big questions that have come up are, because it was retroactive to January 1, employees could choose to apply this retroactively, but employers don't have an obligation to notify employees of that. So they don't have an obligation to tell employees, hey, by the way, you could potentially take the supplemental paid sick leave and apply it retroactively. Employers also don't have an obligation to go back and replenish any sick leave banks. And so what that means is, let's say you had an employee who took 2 days off in February because they were having adverse effects of the COVID vaccine, and they took 2 days of sick leave. So they were paid, under their normal sick leave plan. SB 95 does not require that an employer then go back and replenish those 2 days of sick leave to apply this supplemental paid sick leave. That is not a requirement. So you don't have to go back and replenish because they already got paid for it. That's not the intention of SB 95. However, if that same employee who needed 2 days of sick leave in February did not have any sick leave at that time, and therefore they were on unpaid leave, then that's when you go back and you apply the supplemental paid sick leave and they get pay for that period of time. Another question that we commonly get is the intersection between SB 95, supplemental paid sick leave, and emergency paid sick leave under the FFCRA, now under or extended under ARPA. So EPSL, emergency paid sick leave, was extended through September 30th, but it's optional. So you didn't have an obligation to extend it. It's optional. The issue is that if you decided to extend it, then the employer is obligated to replenish their EPSL banks back on April 1. You were required to do that. And so if you have an employee that used leave between January through March under this extended option, basically, they get a new leave entitlement on April 1. It's 80 hours max. And you're required to do that. And so in that sense, EPSL does not line up with SB 95 because SB 95 is retroactive to January 1. There's no obligation to replenish your banks, right? But it's retroactive to January 1. EPSL, everyone had to replenish in April 1. So whatever happened before April 1 kind of doesn't matter, basically. So one benefit to extending EPSL, however, of course, is that you get the payroll tax credit. California SB 95 does not provide for any sort of payroll tax credit, but under EPSL, you do. The EPSL and SB 95 kind of run identically with regard to the reasons for taking sick leave, except with regard to the issue for childcare. Under EPSL, you have to provide leave for a school closure. Like, for example, let's say a school closed, moved to hybrid instruction or online learning in the fall, and they never reopened physically on campus. That employee may still be entitled to EPSL, but that employee would not be entitled to supplemental paid sick leave. And the reason why is because supplemental paid sick leave, again, it's only if you're caring for a child whose school is closed because of a COVID exposure, basically, on the premises. So it's not that the school just didn't reopen on January 1. There was some sort of exposure, a student tested positive, you have to shut down the school for 2 weeks or something like that. So that's one of the key differences between SB 95 and EPSL, and that's based on guidance that came out last week, actually. So that's relatively new guidance. So other COVID-19 benefits, of course, we have the FFCRA. Again, it's optional, it's no longer mandatory. There are Cal-OSHA requirements that basically, if you exclude employees with COVID from the workplace, you have to continue to provide them with compensation unless you were able to prove that the employee didn't get it from work, basically. And that's a very high kind of threshold to meet. It's very difficult to prove. It's possible if you had, for example, like a multi-week school closure and that's when the employee got sick, you might be able to prove it then, but it's a high standard you have to meet. COVID and disability accommodations. Is COVID-19 a covered disability? Well, it depends. A disability is when you have a medical condition that limits or substantially limits a major life activity. And so when an employee is not able to perform an essential function of their job due to this limitation, so due to COVID-19, then it may be a disability and you have to engage in the interactive process. So we've had many situations with our clients where they had an employee that became sick with COVID and then had lingering effects afterwards that, like respiratory or other issues afterwards, where the school did have to engage in the interactive process to determine reasonable accommodations. Okay, so those are the general categories of leave that we're covering in this session. And so what we're doing next is moving into a longer case study, which is here, as well as a number of questions, which is on the next slide. So what I'd like to do is launch everyone into some breakout rooms. I might pop into some to say hi, so don't be alarmed if you see my face there. And then you can, if you have the slides that you downloaded or printed out, you can then run through the questions. And then what I'll do is when we reconvene, I will go through the answers together. I think what we'll do is, I know it's a very odd number, but I think what we'll do is break out for about 8 minutes or so and then come back and go through the answers. And then we'll leave some time for questions if we have any at the end. So I'm going to go ahead and do this. Okay, so I think everyone should be back. Let me share my screen with the case study questions. So I hope you guys all had fun working through these questions. I'm sure PDL case studies are really fun for everyone. So question 1, should the school code the employee's sick leave request as pregnancy disability leave? So the answer to that, and I'm going to look at everyone's face, see how people think they did this, is that the answer to that is no, not yet. An employee whose pregnancy is making it difficult for them to complete work is not necessarily the same as being disabled by pregnancy. A person is disabled by pregnancy within the meaning of PDL if, in the opinion, of the employee's healthcare provider, they're unable to, because of pregnancy, to perform one or more of the essential functions of their job, or to perform their functions without undue risk to themselves or their pregnancy's successful completion. And so if you have an employee that is kind of, you're not sure basically if they're indicating that they're disabled or not by pregnancy, the appropriate thing to do is to basically ask them to provide, a medical note from their doctor to confirm. It's really not on the employer to assume or to guess, because, we're not doctors, or at least most of us are not, we would have the skills or the background to be able to say whether the employee is disabled or not. But it is really common that employees sometimes, and I'll just use myself again, when I was pregnant, both with my first one and the twin pregnancies, where I had really bad morning sickness, for example. The first one, it was just what I'll call like regular old morning sickness, and I wasn't considered disabled by my doctor, for example. And so I didn't request accommodations or anything like that. With the twin pregnancy, I had really severe morning sickness, the kind of like Kate Middleton kind, where I actually was, certified as disabled basically by my doctor, because I could not do anything essentially during that period of time. So it's not something to assume, it's just really get that information from the doctor. Question 2, may this employee use PDL when school resumes after summer break? I hope that many of you got this correct, because we actually talked about that in another polling question, but the answer is not necessarily, right? So under PDL, the employee is entitled to the leave for the period that the employee is actually disabled by pregnancy, up to 4 months. And so it usually takes about 6 weeks, after birth, or 8 weeks if it's a C-section, where the employee is still disabled. And after that, the employee is no longer disabled. So it's possible that the employee could continue to be disabled after the summer break, but it's typically unlikely, and so in which case it's not PDL that we're talking about anymore, it's baby bonding leave under FMLA and CFRA. So the answer to question 2 is the employee could use PDL if the employee is still disabled by pregnancy. So it's not for baby bonding, but if the employee is still disabled by pregnancy, then she could use PDL. And sometimes that happens for other reasons, such as, like postpartum depression, which can be considered a disability due to pregnancy and things like that. So 3, is this employee entitled to 24 weeks of baby bonding leave for her twins? The answer to that is no, but I will say that I wish that were the case since I had twins. But the answer to that is no. There is actual guidance from the Department of Labor on the FMLA, which says that multiple births do not entitle the employee to additional FMLA leave. So it's still just 12 weeks of leave, regardless of multiple births. So the answer to question 4, are you missing information you need to determine the above answers? If yes, what additional information do you need? Well, of course, my answer as legal counsel for schools is that I always wish we had more information. So the answer is likely yes. Schools may request medical certification, right, to determine whether the employee is disabled by pregnancy. We need to know when she's no longer disabled by pregnancy, which is, again, not something for us to assume. It's for the doctor to tell us. We also, for CFRA and FMLA purposes, we need to ensure that the employee is entitled to the leave, has worked the requisite number of hours and months, for example, confirm that the employer has at least 5 employees for the CFRA or 50 employees for the FMLA. So there is missing information that we need. Question 5, explain what leave this employee is entitled to from the school. So as we mentioned, the employee can receive pre-birth disability PDL, pre-birth PDL, post-birth PDL, and then baby bonding time. So she's entitled to up to 4 months of PDL if she's disabled by pregnancy, and then an additional 12 weeks of baby bonding leave, which is under the FMLA or the CFRA, and you can refer back to that chart. So those are the answers to the case study. I hope many of you got that correct. We have about 1 minute left if anyone has any questions. If Here is my contact information. If we were not able to get to any of your questions, feel free to reach out.
And if I could just jump in a second, this session is, you are eligible to receive SHRM or HRCI credits. So if that interests you, just go ahead and write in the chat your name, your email, and which credit you want, SHRM or HRCI. And I'll take care of sending you more information on how you can receive your certificate. So just pop that in the chat now, if you don't mind. Thank you.
Okay, well, I think we're out of time for this one, but we'll leave the chat open, of course, for anybody responding to this. Thank you all for attending, and I hope you enjoy the rest of the day.
Thank you so much, Grace. Really informative. Thank you.